Appeals, Division 1 is now in session.
Thank you. Please be seated. Okay, good morning. We're here for oral argument in case number 1, CACV 16-0514, Harry H. Wilson et al. Versus Joseph R. Drake III et al. Council, I remind you that these proceedings are being recorded. So we'd ask you to please identify yourselves and your client at the beginning of your arguments. Each of you will have 20 minutes. Appellant's counsel, you'll want to watch the clock to reserve what portion of time you want to save for rebuttal. Also, please keep in mind we've read the briefs and have conferenced the case, so we are familiar with the procedural history and the facts of the case. But with that, counsel, for appellant, you may proceed.
Good morning. May it please the court. Daniel Ariano of Lewis Roca Rothgerber Christie for appellant Joseph Drake. And with the court's permission, I'd like to reserve about 5 minutes for a rebuttal. The trial court ruling from which Mr. Drake appeals spans a single sentence, which reads, in addition, the court finds that the claims are not barred by the statute of limitations. But fact-finding is a function for the jury. And our Supreme Court has made clear that when discovery occurs and a cause of action accrues, are usually and necessarily questions of fact for the jury. Here, applying well-established summary judgment principles, which means viewing the evidence in the light most favorable to Mr. Drake and drawing all justifiable inferences in his favor, shows that a reasonable jury could have concluded that Mr. Wilson actually knew, or at a minimum should have known, that Unit 2 sold in July of 2005. Yet Mr. Wilson did not bring suit until 8.5 years later, in January of 2014, well past the 6-year statute of limitations for contract actions. As a result, a reasonable jury could have concluded that Mr. Wilson's claim was barred by the statute of limitations, making summary judgment improper. And for that reason, Mr. Drake should be allowed to present his defense to the jury. And had he been allowed to do so, there are a number of facts, I think, from which a jury could have reasonably concluded, that Mr. Wilson actually knew around the time of July 2005 when the sale occurred, or at a minimum should have known as a result of numerous warnings. We know from Mr. Drake...
Before you dive into the facts, let's back up just a little bit for my benefit. So, in the briefing, I understood that your argument, at least your primary argument, to be that the Gus Rosenfeld standard applies here.
Correct.
However, I think you'll agree with me that that case did not address any aspect of fraudulent concealment that was at issue in the Walk v. Ring case.
Correct. I mean, it did. So Gus Rosenfeld, importantly, I think, did involve a concealed breach, right? As a result of the law firm in that case asking the leasing agent, has anything occurred that would have triggered our most favored nations clause? And the leasing agent responding that no, it hasn't, but I'll let you know if it does. So
let's assume for purposes of argument that the Walk v. Ring, maybe we're going to go there anyway. Assume that the actual knowledge standard actually applies. What evidence would support actual knowledge? And you were probably getting to that. Or B, is there some middle ground then between Gus Rosenfeld and actual knowledge? I mean, the Walk v. Ring, it vacillates. It seems
right.
to me that back and forth between actual knowledge, and then what a reasonable person would do or could have done to investigate. Mm-hmm. So help me out there a little bit.
So to the extent there's a middle ground, I think, between Gus Rosenfeld and Walk v. Ring, I think that middle ground would be some degree of inquiry notice, which I think even Walk v. Ring recognized. So Walk v. Ring, I think, dispensed with to the extent it dispensed with constructive knowledge, I think it only did so to the extent that you have a breach of fiduciary duty claim. And I think that's precisely because you have in a fiduciary context the fiduciary who is in a position of superior knowledge and the person who's in that fiduciary's trust who does not have access to the information and has every reason to trust that fiduciary. So I think outside that context, I don't think you have the rule requiring actual knowledge. But even when you have, I think, even that fiduciary context, and assuming that standard applied here, you still, WAC still recognized that when you have fraudulent concealment, and as an initial matter, you first have to establish, I think, fraudulent concealment, which is itself a question of fact, I think, as WAC recognized. But once you establish, I think, fraudulent concealment, you still have the standard that the discovery occurs when such concealment is discovered or reasonably should have been discovered. I think that reasonably should have been discovered is a standard that has been applied by Arizona courts since the 1930s in Tom Reed Gold Mine. It's a standard that shows up every time the court mentions the discovery rule. But even apart from that, WAC recognized that a duty to investigate nonetheless arises, and this is at paragraph 35, that a duty to investigate arises when the patient discovers or is put upon reasonable notice of the breach of trust. And I think that standard, I think, is well illustrated by the Arizona Supreme Court's decision in the Tovrea land and cattle case, where the court recognized that, a stockholder isn't required to, continuously check the books. And again, this is assuming fraud again, that a stockholder isn't required to, continuously check the books of a corporation every week or two to kind of be on the lookout for fraud. But once they're put on notice of facts that should have alerted a reasonable person that something was amiss, there is, I think, at minimum a duty to investigate. And I think a failure to conduct even an investigation once that notice has occurred, I think prohibits the tolling of the statute of limitations. And to answer your Honor's question about actual notice, again, assuming that standard applies, I do think there are a number of facts that could lead to the reasonable inference by a reasonable jury that Mr. Wilson had actual knowledge at the time that the sale occurred in July of 2005. We know from Mr. Drake's declaration that he and Mr. Wilson had monthly conversations about the status of the properties between the summer of 2003, when the units were constructed, up until July 2005, when the last one was sold. We know that Mr. Wilson regularly received bills and property taxes related to the properties and managed the bank account for MRAD and occasionally paid some of those bills himself out of that account. And we also know, importantly, that Mr. Wilson received property evaluations with respect to the property, and we have the one we have in the record at Appellee's Appendix, page 315, is a September 2003 one showing a valuation for the 2004 tax year, and that valuation went to Mr. Wilson's address in Lake Havasu. So there's evidence in the record that Mr. Wilson was getting notices about these properties directly in Lake Havasu. And we know that Mr. Wilson visited the property, according to Mr. Drake's testimony, that Mr. Wilson visited the property every 2 to 3 months between 2003 and 2005. And those visits stopped in July of 2005. And perhaps most importantly, we have the letter that Mr. Wilson sent to SRP in July of 2005, the same month that the last unit was sold, telling SRP that a majority of the units had sold and to please transfer power service to the Building Owners Association. But a majority of the units had actually sold a year prior to that date, in May of 2004, when the second of the 3 units was sold. And so we have the fact that the first 2 units sold in pretty rapid succession of one another. The first one sold in September 2003, the second one in May of 2004. And then, according to Mr. Drake, Mr. Wilson did not inquire about the status of the units or request an accounting of any sort until August of 2013, when his lawyer contacted Mr. Drake. And so we have this long period of time in which nothing happens with the property. Again, despite the fact that the first 2 sold pretty rapidly within succession of one another, and the fact that this was a fairly strong real estate market up until 2008. And so the fact that Mr. Wilson let a number of years pass before he even asked about the status of the properties, I think, leads to the reasonable inference that a jury could have reasonably drawn that the property that Mr. Wilson knew that the property had sold in July of 2005, or else he would not have stopped asking about the property or ceased his pretty regular involvement of the company that he had exercised prior to then, or otherwise would not have transfer the power service, to the property owners association, when he could have done that a year prior when a majority of the units sold in 2004.
What about the 3 checks that your client wrote and the insufficient funds? How does that fit into your analysis of this issue?
So I think that fits in the analysis, Your Honor, in that those checks, I think, would at minimum create inquiry notice or constructive notice that something was amiss. Again, these are pretty substantial checks, and I think based on the record, based on Mr. Drake's discovery responses, I think there's some dispute as to whether those checks actually bounced. But even if we take for granted Mr. Wilson's assertion that at each of those 3 checks bounced, again, that's a problem. Assuming that fact to be true, if Mr. Drake had issued the first of those checks, and that, according to the April 2006 letter, was an attempt to purchase out the remaining interest in the building. And that was a fairly substantial check that bounced. There was another one, then there were another 2 in 2007. Again, each pretty substantial. I think the fact that both of those checks bounced, I think assuming that was true, presented a serious problem that Mr. Wilson should have been aware of, that should have at least alerted him that something was amiss, and that would have then created a duty to inquire as to what was going on with the property. And again, he could have done that fairly easily by simply looking at the records of the property, by simply looking up the title records, the promissory note and the deed of trust to JRS Holdings in 2004 was publicly recorded. The sale of Unit 2 in 2005 was publicly recorded. So these were all publicly available facts that Mr. Wilson could have availed himself to have learned of the breach.
Of course, counsel, in April 2006, that's when your client specifically told Mr. Wilson that it was in fact had not been sold, right? Which would be an outright lie, right?
Well, Mr. Drake, I think, did concede in discovery that it was inaccurate to have represented that the property was not sold, as he stated in that letter, when it in fact had been sold. But
So does that event, does that sort of wipe out all prior events? I mean, in the sense that I know you've talked about the 2005 events
Right.
and notifying SRP. I mean, but here you have a situation where in April of 2006, I mean, your client affirmatively represents, to Mr. Wilson, it has not been sold. Why isn't Mr. Wilson entitled to rely on that representation from his co-manager?
So I think a couple of points on that, Your Honor. So the first is that there's a significant amount of time that passes between when the second unit sold in July of 2005 and that letter is written in April of 2006, right? And so these are not kind of contemporaneous events. You do have a long period of time during which I think there are still enough facts to draw the inference that Mr. Wilson knew in that period. The second is, even if we were to not consider what happened prior to that letter, there are, as Judge Downey mentioned, the 3 checks that occurred after that letter. At least one of the checks was sent contemporaneously with that letter. The first check was sent with a letter saying, this is an attempt to buy out the remaining interest, and it was based on Mr. Drake's having sold some of his stock holdings to fund that check. And then you have another 2 after that. And so you still have, I think, important critical facts after that letter is written that would have, at a minimum, have created or have put Mr. Wilson on inquiry notice that something was wrong and that he needed to have looked into the issue further. And again, I'll remind the court that Gus Rosenfeld also, again, involved an issue of concealment. Gus Rosenfeld specifically involved the breach of contract cases, which is what we have here. Again, we do not have a fraud claim in this appeal. Mr. Wilson moved for partial summary judgment only on his breach of contract claim, and the fraud claims were subsequently dismissed. So we have an appeal in a breach of contract case, as in Gus Rosenfeld, and Gus Rosenfeld recognized that where the breach of the contract is difficult to detect or is even concealed, as it was there when the leasing agent made an affirmative misstatement as to the status of the most favored nations clause, you still have the operation of the discovery rule, which in the breach of contract context contemplates an obligation of reasonable diligence on the part of the plaintiff. And also, and as recognized, I think, in Gus Rosenfeld and even in Walk, when the either actual or constructive notice occurred are fact questions for the jury. both Gust and Walk recognize that. And again, even assuming that you have fraudulent concealment, which I don't think is established here, whether fraudulent concealment occurred is a fact question. I think that's one of the reasons Walk remanded to the trial court to determine not only whether a misrepresentation occurred, because you had, I think, a misrepresentation of Walk. You had the doctor who told the patient that he had done nothing wrong, but the court nonetheless remanded to determine what the doctor's intent was in making that statement, which I think suggests that the issue of fraudulent concealment is a multifaceted one, as fraud is generally. Fraud is more than just a misstatement. Of course, a number of elements of some of what, a few of which include, the plaintiff's, the misrepresenting party's intent of making the statement and intent to rely on it, justifiable reliance, and a number of other factors. And the court I think that the reason that Walk remanded to the jury was for the jury to make those determinations of fact, I think, as would be necessary here, even if there were an issue of fraudulent concealment. And with that, I'd like to reserve the remainder of my time.
Okay. Thank you. Mr. Murphy?
May it please the court, Brian Murphy of Birch and Cracchiolo for the plaintiff appellee, Adrian Wilson. I'd like to start with the basics. The statute of limitations is an affirmative defense. The burden of proving that fell on Mr. Drake. Another basic, fraud practiced to conceal a cause of action will prevent the running of the statute of limitations until its discovery. That's from Acton v. Morrison, which also stands for the proposition that applies regardless of the nature of the cause of action. And finally, I'll get to Wells Fargo Bank versus Laborers Local number 395. There are three distinct types of fraudulent concealment. There is fraudulent misrepresentation under Section 525 of the Restatement Second of Torts. There's nondisclosure under Section 551 of the Restatement Second of Torts. And there's fraudulent concealment under Section 550 of the Restatement Section of Torts. The main distinction between nondisclosure and the other two is there must be a demonstration of a duty to speak for that to apply. The other two do not involve duty because Wells Fargo specifically said duty is a concept that relates to negligence. Where there's an intentional tort involved, there is no demonstration of duty necessary. Here's what we say. All three of these fraudulent misrepresentations apply here because there was a scheme of misrepresentation. In July of 2005, Unit 3 sold, which triggered a duty under Section 3.3 of the operating agreement for Mr. Drake to inform Harry Wilson the unit sold. Failure to do so was a nondisclosure because he had a contractual duty to speak that violated Section 551 of the restatement, and it was a concealment of material facts under Section 550. But then we get to 2006. In April, he sends a letter which specifically misrepresents that Unit 3 had not sold. And then the checks start coming. Those go on through February of 2007. What do we make of those checks? These were gratuitous payments by his description. The unit hasn't sold, but I'm reaching into my own pocket. In April of 2006, he said, I'm selling stock to pay you off. Give me until April 20 because it hasn't cleared yet. But when he tried to cash it, it bounced. And then he wrote two other checks through February of 2007. Those were drawn on the account of a company called No Fire Marketing, LLC. Completely unrelated to this. Mr. Drake represented, I'm reaching into my own pocket to pay you off, and doggone it, I'm just short on the funds, but I'm trying to get you paid. That was part of a lulling scheme, we state, which reasonably would lead Mr. Wilson to relax any diligence that he had.
Counsel, how is paying, help me understand how paying, there's three checks.
Yes.
Two are payable to the LLC. One is payable to Harry and Francis Wilson.
Yes.
For $30,000. Put that one aside for a second. The two majority that constitute almost $1 million, they're payable to the LLC. How is that paying off? I mean, Mr. Drake is a 1/3 owner of the company. He's paying himself for 1/3.
That is correct, Your Honor. And the best we could state with regard to benefit to Harry Wilson would be that he had a promissory note due to him for $975,000 from Master Real Estate Development, LLC, to himself and his then wife, Francine. But that promissory note was only due on the sale of the last of the condominium units. So How that would have flown to Harry Wilson under these circumstances where the unit had sold but he didn't know it is hard to say, had those checks cleared. Have I addressed the court's question?
Well, yeah. Does the record show, I don't recall saying anything, but does the record show what Mr. Wilson tried to do with those checks? Did he try to deposit that into the LLC account?
No, Your Honor. He said he went to the bank, and I think he said, I'd have to check the declaration, but it was attached, the verified complaint recites, and as I recall, he went to the banks and attempted to cash the checks, but before they were negotiated, the bank said there's insufficient funds on each of the 3 occasions. That's my understanding of the record.
Okay.
Getting to Walk versus Ring. There's no doubt that that decision of the Supreme Court drew a clear distinction between the discovery rule and fraudulent concealment. And it said both had to be analyzed separately because if one did not apply, the other still might, i.e., the discovery rule goes to when a cause of action accrues. When does the clock start ticking? Fraudulent concealment goes to tolling, i.e., even if the clock has started ticking, it may stop for a period of time if there's certain misconduct by a defendant. So those are distinct concepts, and they were analyzed distinctly. And what Walk said several times is with regard to a fraudulent concealment, there is no duty of due diligence. It said it expressly. And we'll get around to the language that they rely upon, which said that tolling would stop when such concealment is discovered or regionally should be discovered. And here's how I believe we can harmonize the holding there. 1, the discovery rule applies when you knew or should have known. There is an obligation of diligence and investigation. 2, fraudulent concealment has no such obligation, and actual knowledge is required to stop it from tolling. But actual knowledge is measured against an objective standard, i.e., and I use the example of the Walk versus Ring case. There, Dr. McDonald, an expert, mailed a report to Dr. Ring and the insurer stating, I believe this patient was injured because you malpracticed. That was never told to the patient. Let us assume that Dr. McDonald had also mailed that very letter to the patient, Walk. But Walk had either not opened it or had cast it aside. A reasonable patient would have had actual knowledge at that point, and that's what would cause it to run. But under the discovery rule, even if that report had not been received, there might be a duty to investigate whether such a report existed. So I think the distinction is this. Actual knowledge is measured against an objective standard, but actual knowledge is required before you will state that the tolling of the fraudulent concealment ends. And I would point out the following. Drake's position would render the distinction between fraudulent concealment and the discovery rule superfluous. They would be identical. Both would toll or both would end when someone reasonably should have discovered facts giving rise to a claim. And that is certainly not the lesson that Walk versus Ring taught. Let's get to Gus Rosenfeld then.
Before you leave
Yes.
Walk, could you go to, do you have the Walk case in front
I
of you?
do not have it in front of me.
Well, in paragraph 43, which is the conclusion, which normally courts, I don't know, presume, I guess I shouldn't presume if they intended that to be their holding, but it's one thing they said. Okay, I'll just put that. The court said, reasonable minds could differ with regard to whether, more than 2 years before filing her action, plaintiff knew or should have known facts that would have put a reasonable person on notice to investigate whether her injury had been wrongfully inflicted. The same is true regarding her claim of fraudulent concealment. What should prevent us from just using that as our standard to evaluate this case?
Because, Your Honor, that too would render the distinction between the discovery rule and fraudulent concealment superfluous, which the Walk Court specifically took pains to analyze these distinctly and said, we are going to reach the issue of fraudulent concealment specifically because the jury may rule against the plaintiff on the discovery rule. So that's why we have to get to element 2, fraudulent concealment. And
But is that just sloppy language by the court?
Your Honor, it may well be, and I have a very difficult time, of course, putting myself in the mind of a court, but all I can say is I could not ignore the rest of the decision based on a statement of that character at the conclusion, because the very analysis that the court went through first analyzed discovery rule, then analyzed fraudulent concealment, was announced by the court on the basis that we're going to get to second step to the fraudulent concealment because the jury may rule against the plaintiff on the discovery rule. And that could only be the case if one was capable of losing on the discovery rule, but winning on the fraudulent concealment. And if the courts, if Judge Brown's analysis is correct, those should be no difference. If someone should reasonably have discovered the facts giving rise to a claim, that would stop both the discovery rule, that would start the accrual under the discovery rule, and would also end the tolling under the fraudulent concealment at the very same moment. There would be no distinction, no reason to analyze those concepts separately. And that gets to Walk versus, Gus Rosenfeld. Gus Rosenfeld, as the court pointed out, only considered the issue of the discovery rule. It never got to fraudulent concealment. Why? It didn't need to. It found that there was a basis for relief to the plaintiff just on the basis of the discovery rule, i.e., the plaintiff should not have reasonably known sooner than it did that the lease had been given to, a cheaper lease had been given to Snell and Wemmer, and so they didn't have to go further. And we don't know for that fact whether the plaintiff actually raised the issue of fraudulent concealment in that case. It's not clear from the record at all. But we can say this much. The case had nothing to say about the concept of fraudulent concealment. Nothing in Walk versus Ring suggests that the phrase fraudulent concealment should be limited to a case where there's a fiduciary duty. To the contrary, that was important there only for this reason. As I mentioned, under the restatement rule, nondisclosure requires a duty to speak. In that case, the duty to speak was based on a fiduciary relationship where there's an affirmative duty of disclosure. In our case, the duty to speak is based on a contractual provision. Managers shall reveal all material facts to the other managers. So in that regard, we are compliant. But nothing in Walk versus Ring said we are not going to apply the lessons of this case to fraudulent concealment based on affirmative misrepresentation. We're not going to apply it to fraudulent concealment based on concealment under the restatement rule. And I submit that limiting it in that fashion would be a misreading of the case, particularly because we have cases such as Acton versus Morrison stating that fraudulent concealment applies to any cause of action, at law or in equity, and tort or in contract. And now let me discuss, if I could, the issues that they have raised with regard to, Mr. Wilson should have known of the things going on here. I will start with the Restatement Second of Torts, Section 540, a section that has been adopted by Arizona decisions on at least 4 occasions. And I quote, "The recipient of a fraudulent misrepresentation of fact is justified in relying upon its truth, although he might have ascertained the falsity of the representation had he made an investigation." And that is revisited in Barnes versus Lopez, I beg your pardon, and Formento versus Encanto Business Park, which stood for the following proposition. I'll quote from Barnes versus Lopez. "Where here, a positive, distinct, and definite representation as to the zoning status of the property was made, Lopez was entitled to rely on it and had no duty to make further inquiry. This is true even though the facts could be ascertained by an inspection of public records." That's an Arizona decision. Why is that crucial? For the following reason. Inherent in the position that under the restatement rule, a person may justifiably rely upon an affirmative misrepresentation, even if he could have ascertained its falsity by investigation, is the concept that misrepresentation suspends the recipient's duty of due investigation. That is inherent in that concept. And that, we say, is precisely the lesson that Walk versus Ring said. Where there's a fraudulent concealment, in any of its forms, I submit, that suspends the recipient's duty of due investigation, because you are entitled to rely on the truthfulness of someone who has said something to you point blank. And there can be no doubt that on April 3, 2006, I hope the court gets a chance to read the letter that we attached to our summary judgment pleadings, which is item 16 in the record below. This letter didn't just say the property hasn't sold. It said, my goodness, we've tried so hard. We tried. I thought my partners were going to buy it. Then the bean counters got involved and they scotched that sale. And I've been out there cleaning the fountains and taking care of it, and doggone it, I'm so sorry we haven't. But here, I'm giving you a check that's drawn on my own personal stock account. Give it a couple of weeks to clear and then go ahead and cash that, but I'm paying you out of my own pocket. This was not just a misrepresentation. This was a conscious scheme to deceive. And it cannot be read in any other fashion. And the lesson of the law is this. We are not going to reward that kind of conduct. And I have quoted to the court in my brief, Lubin versus Johnson. And I quote, "There's nothing particularly attractive in the proposition that an insurer or anyone else may by misrepresentation induce a person to forego rights and then defend on the ground that the fraud is excused because the person defrauded should have known better. We are unwilling to endorse the idea that victimization of the ignorant has legal sanction. That precisely, I submit, is what Mr. Drake is trying to do. He has never contested that he wrote the letter. He's admitted that. He's never contested that the letter included a false statement regarding the sale of the property. He's never contested, even in his declaration, that the purpose of that was to deceive Mr. Wilson into not thinking that the property had sold. But now he's trying to state he should have found out sooner. Why? Primarily because of recorded documents, the warranty deed and the deed of trust. That takes us straight to Restatement Section 540, which says that if there's an affirmative misrepresentation, there is no duty on the part of the recipient to investigate, even if a recorded document would have shown otherwise. And comment B to that section says specifically, this applies even if there is a recorded document. And that was also the lesson in Barnes versus Lopez. There was a zoning issue that could have been examined by discovery of the record, a review of the record. So the long and short of it is this. We're invited to forgive Mr. Drake theft from his own LLC. He took $350,000 of money that should have gone into the LLC's pocket to pay off a personal debt, not disputed, admitted in his interrogatory answers. And to conceal that by statements that he made to my client to the effect that it hasn't sold, I can't, you're not due your money yet, but I'm going to pay you anyway out of my own pocket. Oh, that didn't work. And now he's stating, oh, you waited too long. You should have known better. But bear this in mind. What he has to show is that on the record, we should have known before January 24, 2008, that he had told lies, that the property had sold. January 24, 2008. The statute is provided by ARS Section 12548. It is 6 years. We filed on January 24 of 2014, going back 6 years to January 24, 2008. That is what Mr. Wilson has the burden of proving. Mr. Drake has the burden of proving. That on or before January 24, 2008, he had actual knowledge that he'd been lied to, that the property had been sold, and that Mr. Drake had put $350,000 of partnership money in his pocket. Nothing in the deed said this puts money in Mr. Drake's pocket. Nothing in the deed of trust, which was between Master Real Estate Development LLC and this JRS Holdings. Nothing in the deed of trust said, I have taken money out of our own pocket. There was nothing to indicate to anyone of record that he had stolen money from the LLC. That is the fact that they must show, because that's what triggers our cause of action. Nothing to show that until he answered an interrogatory in our case where he admitted that he took the funds. That is the first time there was actual knowledge of the facts that actually matter here. Even if recorded documents would reveal that, they didn't. They would be irrelevant under Section 540 of the restatement. But I submit to the court that there is no justification for stating that there's not a tolling here, and there were no fact controversies raised. You will note as you review the record that there is no statement by Mr. Drake about when he told Harry Wilson Unit 2 sold. No statement by Mr. Drake about when he told Harry Wilson, I took the money. There's nothing in the record to that effect. What he said about the sale of the property in his discovery responses, which are in my brief, is, I don't remember when I told Mr. Wilson that the property had sold. I don't recall. That's the best record that he can make when he has the burden of proving that on or before January 24, 2008, my client had actual knowledge that the property had been sold and that he had converted sales proceeds. Not just the sale, but that conversion of proceeds had occurred in his favor. That is there's nothing in the record to indicate that my client knew or should have known of the conversion of funds, because that was an arrangement that Mr. Drake had made entirely on his own. He encumbered partnership or LLC property for his own benefit, didn't tell us about that, had the escrow company pay that off out of the sales proceeds, and there's nothing of record that would have had anyone to guess that based on his own misconduct. Even if there were a duty of investigation, which we deny, that investigation would not have revealed the facts which give rise to our claim. Unless the court has questions, I've completed my presentation.
Questions? No. Thank you, counsel.
I thank you.
Thank you. So, Arizona obviously has a rich body of case law on various fraud doctrines, I think, as the Wells Fargo case explained. And this case is as simple as if Mr. Wilson wanted those fraud principles to apply, he could have maintained his fraud claim. He could have moved for summary judgment on his fraud claim. He didn't. Mr. Wilson wants this court to assume, as it wanted the Superior Court to assume, that there was fraud here. And I can appreciate why that assumption is attractive in light of the April 2006 letter, but I remind this court that fraud is multifaceted. It is more than just a misrepresentation. You have to, of course, show that the intent of the actor was to mislead. You have to show that the recipient of the representation was justified in relying on it and was in fact misled. And we cannot, on this summary judgment record, establish those facts, again, primarily because there was no motion for summary judgment on fraud. And so I think the fraud principles discussed in Walk v. Ring, the fraud principles discussed in Wells Fargo or in the restatement second, do not apply to this case, again, precisely because we do not have a fraud claim. But even...
Counsel, they did apply, and we did not lose that fraud claim. Totally set your argument on its head.
I'm sorry, Judge,
If they hadn't dropped their fraud claim, if this was specifically a fraud claim, you don't have a challenge to the statute?
Oh,
argument?
absolutely, Judge. Yeah, I think even if we were to apply fraud principles, I think there is still a fact question. Again, because the question of fraud is itself a fact question, right? And here we do not have a factual determination or a ruling by the Superior Court that no reasonable jury could have found that there wasn't fraud, right? So we do have an open factual question on the issue of fraud itself. Again, assuming it applied. But applying fraud principles...
Counsel, just for clarification, those claims still exist?
I believe they were dismissed prior to judgment, Your Honor, but what is clear, at least on the summary judgment record, is that Mr. Wilson moved for partial summary judgment only on the breach of contract case.
Okay, thank you.
But again, even applying fraud principles, for example, look into the restatement. Mr. Wilson is correct that restatement section 540 says that, a victim of a fraudulent misrepresentation for purposes of the justifiable reliance element of the tort does not have an affirmative duty to look at property records. That is true in the context of fraud. Section 541 of the restatement, though, I think states the principle that a recipient of a representation can also just bury his head in the sand, right? I think the restatement uses the language of a mere cursory glance would have disclosed the falsity of the representation. You don't get tolling. And here, I think that quite literally applies because a mere cursory glance at the unit itself would have shown that it was occupied. Valley Oaks Imagery started occupying the property immediately after it purchased it in July of 2005. And in fact, by Mr. Wilson's own account, he discovered that fact when he visited the property in the summer of 2012, I believe, and looked in the window and saw that the building was being occupied, right? And so I think even applying, as Judge Campbell mentioned, those fraud principles here, you still have a fact question as to whether fraudulent concealment occurred, precisely because we have questions of whether Mr. Wilson would have been justified in believing the representations. And you also have, and for what it's worth, also have a record, I think, on a fact issue, on what the intent of Mr. Drake was in writing that letter. Again, intent is also itself a question of fact, as Walk v. Ring recognized in remanding to the trial court for the jury to determine what the doctor's intent was in making the representation. Mr. Drake did state in his declaration on summary judgment that he did not intend, by virtue of writing the April 2006 letter, to hide the fact of the JRS loan or to hide the fact that the proceeds had been used to pay off that loan. And I think Mr. Wilson also tries to draw what I think is an untenable distinction between the fact of sale and the misdirection of the proceeds. I don't think that those two can be separated for purposes of notice of what had occurred. The argument of Mr. Wilson, as I understand it, is that even if Mr. Wilson knew that the property had been sold, he was still justified in waiting longer to sue because he could not have known that the proceeds of that sale had been misdirected. But Mr. Wilson had a nearly $1 million promissory note due to MRED. And per that promissory note, the sale of the last of the 3 units would have triggered a pretty substantial repayment obligation of the nearly $1 million in principal plus 6% interest per year. And so the sale of the unit, assuming Mr. Wilson was aware of the sale, he necessarily would have been then awaiting the proceeds of the promissory note, which he never received. And if the court has no further questions, I think that's all I have.
No.
Thank you.
Counsel, thank you both for your arguments. The Court will take this matter under advisement and issue decision in due course. We'll take a brief recess to prepare for the next argument.